overwhelming view of the profession, which is really what you rather implied at the beginning, or does it tend to be, and I suppose I'm asking you to draw out really from the figures and different things like that, the view that's overwhelmingly driven by the large firms, because that's certainly the impression one gets from the evidence we've heard so far, or seen so far.
I say with due modesty, I mean, a number of the people around this table know me and know the sort of law that I practice, and I've never worked for a large commercial firm. I've got no interest in ever working for a large commercial firm, and I've always been a supporter of this policy, and I know that there are a large number of other people who are in the small firm sector who can see advantages of it. One of the things that we have, I just give you this as by way of a very practical example. The present moment in time, you cannot provide legal services to the public if you are not in a business which is wholly solicitor-owned. Now, Mrs Craigie and I know someone who's a local solicitor in Cumbernauld, he lives elsewhere now, who practices in the field of employment law. And his business model involves him, a management consultant and an HR professional, and they have a business that gives advice. If their clients are taken to an employment tribunal, it is possible for him to represent people at that employment tribunal because it's not in the reserved area. But if his clients are sued in court, it is illegal for him, indeed it's a criminal offence at the moment for him to represent these people in court because his business structure doesn't allow that. We don't think, we heard the evidence that was given by the OFT. We have to say we think this idea of your routine high street surveyor and your routine high street solicitor getting into the same partnership is fanciful. But we think that for specific kind of bespoke purposes, there might be business vehicles which involve a solicitor as one of a number of people bringing together different skills, possibly to deliver a specific bespoke service. And we don't have a difficulty in principle with that.
I mean, I can see the argument in the way that you put it in that respect, but I can also see possible limitations in other directions. Can I try and break it down a little bit? I mean, there seem to be kind of a number of different areas. There's a question of the ability of Scottish law firms and English law firms to be in partnership together. That's presumably relatively uncontroversial as far as that's concerned. There's the issue of lawyers, accountants, surveyors, that sort of direction of travel. And one can see again, I suppose, in the tax field, maybe issues to do with lawyers and accountants, there's a certain match there. But there's perhaps begin to be difficulty if you talk about surveyors, as was suggested certainly by the OFT and people. I mean, there's lots of conflicts of interest problems there, isn't it, not to beat about the bush?
The point that you made, because I didn't see the evidence, but I had the opportunity of reading the transcript of the evidence, that suggestion that within one business, that a surveyor might value the house for the seller and a solicitor then act for somebody else as the purchaser is inconceivable to us as a business model. I mean, there's just such a patent conflict of interest. You described it yourself as extraordinary. It was a very bad example for them to have chosen. You can, however, see a situation, I come back to the bespoke model, you can see a situation where somebody might put together a business that says, we will have a surveyor who, say in land acquisition, we will scout out the land for you, we will have a land agent, we will have a surveyor, and we will have a solicitor, and we will deliver you a seamless service that involves the identification of the ground, the valuation of the ground, the negotiation of the price, and then the acquisition, all done by one partnership with different professionals within that partnership. And we don't have any difficulty with that as a business model.
Does that lead into the area, if you like, of the lawyer, non-lawyer problem as to what sort of non-lawyers you can go into partnership with, in what circumstances, and for what purposes? Because we come to this, don't we, in the terms of the kind of the regulation of will writing, for example, which is one of the issues that was raised before. Now, on the face of it, this example given the Scottish Law Agents Society evidence about the kind of non-legal advice will writing made one's hair stand on end, may I say it as a former solicitor. Do you have any observations about the areas in which legal practice, really it's the brain surgeon issue, if I can follow the point, are there areas of legal practice which should be done only by lawyers, and are there areas of legal practice where, in effect, it's not kind of as exclusive as that, and the professional training is less important?
If you don't mind, I'll pass this to others to answer, because I'm conscious I'm doing all the talking. Michael, if you would like to deal with it.
Yeah, well, of course, the reserved areas under the Solicitors Scotland Act 1980 are not affected by this bill, and so therefore the preparation. Yes, indeed. They are the preparation of writs relating to conveyancing, the preparation of documents in respect of confirmation of executors, and writs relating to court process. And those reserved areas can only be done by solicitors in certain particular other professions. To do them for gain in any other circumstance causes that to be an offence. So therefore, I think one would say quite clearly in answer to your question that there are reserved areas which will be unaffected by this bill and that they will still have to be done by a solicitor in a licensed provider situation. And remember that in a licensed provider firm, if such creatures come into being, the head of legal services has to be a solicitor. So therefore, one can envisage that the head of legal services will be responsible for ensuring that there is compliance with the law and practice in relation to the preparation of these kinds of documents.
Are the list of reserved issues wide enough? Should there be additions to that?
Well, we have spoken about our concerns in respect of unregulated services, and I think it's fair to say that in relation to will writing, we have concerns about unregulated will writing services, and so therefore to bring that into the reserved areas in some way, or rather to extend regulation to those services, would certainly be something which we would sanction.
And in a sense, a sort of final point, if I may, on this, on the kind of sort of people problem, you know, who should go into partnership with lawyers, how does it all work? Is there not further work to be done on sort of digging down into that? Because one has the feeling that there's, you know, we're coming out with the evidence on some of these things, and there are areas which perhaps we haven't thought about. You're giving a particular view about that. Is there more work to be done on identifying perhaps limitations, restrictions, expansions, whatever, on who you can go into partnership with and for what purposes, and how that's regulated?
We, first of all, we should just say this legislation is permissive and for the avoidance of any doubt. And we would certainly anticipate that in terms of our regulatory rules, there would undoubtedly be restrictions on to whom one would be in a position to go into to partnership in terms of a model that we would be prepared to regulate. We've indicated that our policy inclination at the moment is that we would only be prepared to regulate something that was clearly and primarily a legal business, which may have other areas to its activities. Now, the bill doesn't give us monopoly regulation powers, and other regulators could enter the market, but the other regulators would have to show, before they were allowed to be regulators, that they had appropriate rules and codes in place to deal with that. It's also quite important at this point just to deal with the question of external ownership, because we've talked only at this point about partnership. External ownership is almost a separate matter. As I said earlier on, external ownership could be in certain circumstances internal ownership as well in terms of employee participation. But the bill quite specifically provides for a fitness to own test to be passed, and we are strongly of the view that that's an absolutely essential part of this. I think it's sections 50 and 51 are essential to this legislation as presently drafted, and if that wasn't there, the bill would not have our support. We make no bones about that.
Okay.
Kelly.
Thank you, Convener. Just going back to the vote that took place in order to establish your support for the bill, from the figures that you've provided, less than 10% of the people that actually attended the meeting, made up the overall vote, and 752 of those votes would seem to have been proxy votes. How would you defend, criticism that that a situation could arise where one person from a firm may turn up with 30 or so proxy votes to cast them in favour? How would you defend criticism that that's potentially undemocratic compared with a ballot that you may have run a postal ballot, given one member one vote and a secret ballot?
I should just say, for the avoidance of any doubt, that this was not a single event that took place. The AGM was the culmination of, we had a lengthy consultation process throughout the profession. The Law Society is governed by a governing council, which is 53 members elected by all sections of the profession, 44 of them elected by geographically and with a further 9 selected from particular interest groups of the profession, such as the Fiscal Service, Scottish Government, legal representative, local government legal representatives, some